Okay.
Oh, that's Mr. Moses.
Yeah, there's Robert somewhere. There's Michael. There. All right. Are we unmuted, everybody? Good.
Guys,
Everybody here?
Yep.
Okay.
aye.
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 One more minute and then we'll go.
The meeting. I'm cooking it because it's ready.
I can see it right here. Yeah, yeah. What is? All right. I gotta tell you, Ron, you make me sound better than I actually am. I'm impressed. I'm always impressed.
Please, you do sound better than you think you do.
All right.
Because I'm impressed when you're talking. Son of a gun, I didn't think of that.
All righty. Yeah, it's an Apple, right?
Yeah,
Yeah, okay.
yeah, it's connected to the speaker.
I might do that anyway. All right, we got Jim too. Okay.
There you go. I like this setup. Much better.
Yeah, this is better.
Big screen and-
Well, 7:01, shall we? Because I know Michael's on a bit of a time crunch here. That's what we got to do. All right, everybody, let's open the meeting. Let's have the Pledge of Allegiance. Pledge of Allegiance to the
To the
flag.
flag, of the United
United
States of
States
America,
And to the
to the
republic
republic for which it stands, one nation,
under God,
under God, indivisible, with liberty and
justice for all.
justice for all.
Okay, very good. All right, everybody. This is July 30th, 2020. It's just after 7 o'clock. This is our Smithfield Township Planning Commission work session. We usually only do this when we have certain special things on the agenda. And when we had our meeting on July 9th, the issue came up of the curative zoning amendment request of Water Gap Partners. And it was moved to be tabled to this particular meeting. I'll say we have a quorum present with Michael Albert, Robert Moses, Doug Scriver, and myself. Present on screen, we have several people, including Jim Ferrari, who I know is an attorney that's been involved with this litigation. Present in studio is Andrew Wolf, who is the attorney for the Water Gap property. And ma'am, in the middle, top screen in the middle, I don't know what it looks like to you, but I don't know who you are. I'm sorry.
Teal?
Is it Mrs. Teal? Okay, thank you. All right. I know Ron gave us the minutes from the last one, but I don't know if did you email them around or did you just do them to here, Ron?
No, I think I emailed them around.
Okay,
I could be wrong.
all right.
Scott, Doug, Strunk, Moses, Albert.
Yep.
Robert, Jacob, and Lois.
All right,
So they all have been passed around.
all right.
Doesn't mean you read them though, because.
No, we were reading them beforehand, and to be honest,
For me, I get stuff, but doesn't mean I read it.
I'm certainly okay with them. I'll move to approve the minutes of the July 9, 2020 meeting.
Second.
Seconded by Doug Scriver. Board members, all in favor?
Aye.
Okay. All right, so that is approved. All right, let's move on to the one thing on our agenda, which is the curative amendment request. In between here, we have a letter from the Monroe County Planning Commission, July 9, 2020, regarding the curative amendment. And it's their request. Did you take a look at this, John, at all?
Not really, no.
Okay.
Not that long.
No.
John can read them all.
Yeah,
Sitting
you
here for a
please. It seems like it's fairly straight up stuff with the municipal planning code and so forth. I don't think there's anything that they have that's new that I see here. So we can just make this part of the record, I guess. Let's do
Yep.
that. And we'll also make the June 12 letter as part of the record as well, that Mr. Wolf sent in to Brian Barrett as the chairman of the supervisors,
Oh, his curative amendment.
the
Okay.
curative amendment request, yeah. So that we have it. Now, question for you, Ron. 2 nights ago here, we did, the Board of Supervisors approved the economic development zone amendments to the zoning, both to the zoning and to the zoning map that we'd been discussing for a number of years. In that, you know what I'm going to ask?
Go ahead, keep going.
Okay, in the amendments, it is specifically included in the amendments for this type of facility that Water Gap Capital Partners is seeking the curative amendment. Does the fact that we have now made a provision for this as a township change the need for a curative amendment, or should the applicant simply be asking for a regular zoning amendment through the Board of Supervisors?
Well, let me ask the second question.
Okay.
Certainly, the applicant can always ask for a zoning, a municipal amendment or a zoning amendment to the ordinance.
Can everybody hear him
No,
online?
Not
Just a
well.
little.
Here.
Not well.
Ron, come over here.
No.
I want everybody here. Yeah, that's good. All right, go ahead. Sorry.
All right, so I'm going to answer the question in reverse. Certainly, a property owner can always make a request for a zoning amendment. It's been done several times here in the township. But that is a legislative act, and that means that if the township supervisors say no, there's no appeal of that decision. And so the applicant here is making a request to ask that the ordinance be cured, and that does require public hearings. It does require, or it does allow an appeal, etc. In this particular case, I had said at last meeting that I thought the ED, Economic Development Zoning Amendment, would cure the defect, and that should hopefully take care of it. However, I have since done some additional research, and there is a case called Piper versus Bedminster Township. It was decided by the PA Supreme Court, and although the decision of this case is not on point, the dicta is. And when I say dicta, that means additional language that doesn't decide the case, but in fact tells us where things may be. And that case just seems to say that, just give me a second because I made some copies here of just some of the language that the municipality cannot be permitted to modify or amend its ordinance in such a way that the defect was cured, but the landowner who had raised a challenge obtained no relief. Basically, they're saying that unless the ordinance, the ED ordinance, was advertised prior to the filing of the municipal curative amendment, and that of course is not the case. The court's decision came down on, I think, June 10. The municipal curative amendment was filed on June 12, and then the ED amendment was advertised, I think, in early July, that would indicate that the ordinance cannot be used to stop the request for the landowner curative amendment. Now, that doesn't mean that the landowner curative amendment is just given a absolute imprimatur without any conditions or discussion. There needs to be a hearing. There needs to be a review here by this commission. And then at the hearing, there will be a decision as to whether or not the ordinance should be permitted. Is it reasonable, et cetera, et cetera. And so I think we still need to have a review, and I think we still need to go with the hearing. I know I spoke with Attorney Ferrari earlier today, and he may disagree with that interpretation, and I can appreciate that. I also spoke with Attorney Wolf with respect to this interpretation, and I think he does agree with it, as would be expected, since obviously he represents the applicant. I don't know how we get around that Pennsylvania Supreme Court case that, basically says that,
Ron, what's the site on that, just for my own?
just give me a second, because
If you have it.
I have it, but.
Okay.
I can give it to you, Scott.
What is it, Jim?
It's 30 A 3rd 1083.
Okay.
It's a Pennsylvania
83.
Supreme Court. It's really the last pronouncement of the Supreme Court on these curative amendments.
Okay.
2011.
In 2011.
September of 2011.
Okay, thanks. Just for my
So now, obviously, lawyers can read things different ways, but that's how I'm reading it right now. So
okay.
doesn't necessarily mean the township has to agree to the municipal curative amendment. It simply means that there has to be a hearing on it, that the adoption of the economic development district last week doesn't simply say, okay, it's done, forget it, and see you later.
All right. Now my
And,
second.
and the applicant has a right to an appeal then. I think that's the biggest part
Well,
of this,
sure.
right?
Yeah.
And so do the property owners if in fact the decision goes the other way.
Now.
Ron, I have a question. This is David.
Oh,
Didn't
you're
we
in,
start?
Dave. I didn't hear you.
Yeah,
Okay.
didn't we start this ED process way before the water gap came into us? That
Oh.
would have included that.
There is no question that it was started, at least thought of in process, et cetera, way ahead of things. However, in order to have made it a block, if you will, to the curative amendment, and I'm just want to get that section here. All right, the township would have had to declare by formal action that its zoning ordinance was invalid and propose a curative amendment to overcome the validity. Within 30 days of that declaration, then the township had to, by resolution, make specific findings showing the invalidity, references to specific uses which are either permitted or not permitted, refer to a class or use which requires revision, or reference the entire ordinance which requires revisions, begin to prepare and consider an amendment to the zoning ordinance to correct the invalidity, and it goes on and on. So all of that would have had to be done in order to have the ED amendment be a block to the present municipal curative amendment. That simply wasn't done. There was talk and there was work on the amendment, et cetera, but I don't think that's enough to carry the day in order to say, well, the municipal curative amendment would not fly.
So may I ask a question, Ron?
Sure.
Go ahead.
Mr. Chairman. Question is, so what in effect could be the result of agreeing to a curative amendment vis-a-vis our residential zone versus, so what we would be left with, if I've been reading it right, would be an amendment that would allow drug and alcohol rehab places in residential zones throughout the township, as long as they're 25 acres or greater.
Mhm.
And we would also be able to have them in the ED zone. Is that correct?
No. Right now, you have advertised and have passed the Economic Development District, which
Right.
says that in that zone, you can have as a permitted use a drug and alcohol treatment
Right.
center.
Right.
If someone would come in now and say that your ordinance is bad and I want this in a commercial zone, I want this in another zone, you can now say, you meaning the township can say, no, you're too late. You came in too late. So this particular application, unless I miss my guess, is simply for Water Gap now. This is a
Right, it can't be for any
site-
other ones.
Right, a site-specific relief that would be given if the township would want to grant the ordinance. So it's
Well,
not going
except
to
that, that's not what the ordinance says. That's not what the proposed ordinance
Jim?
says.
Hang on.
Well, I had a follow-up.
Yeah, go ahead.
Can I do that?
Yes.
My only follow-up is this. What's the difference between this curative amendment that we're considering and spot zoning?
spot zoning, you are basically saying that you want to create an island of some type in a zone. You want a residential pocket in a commercial zone. You want a commercial pocket in a residential zone. This is not creating a pocket. This is saying your ordinance is defective. You do not have a place for a drug and alcohol treatment center before ED now. Remember, we got to ratchet back as to where it was in June.
I heard.
And consequently, we believe that it should be in this district.
Yeah.
So it's a different look. You know, and
However,
it's permitted.
the board,
The effect is the same, but, okay,
Perhaps.
Yes, the effect is the same.
sorry.
Yes, Michael?
however, the board could, this is not saying that it has to be approved. A curative amendment basically says you have to cure it, and we have to hear this request. But the answer could, which then would have the right to an appeal, could effectively be, yes, we agree it should be cured. We believe it should be in the economic development zone. And we have now approved that already has happened. That is our response. You're welcome to appeal. I mean, that is a possible, I'm not necessarily recommending one way or the other, but that is a possible response, correct?
That is a possible response. Sure, because again,
The
you are
supervisors,
conducting-
we're not doing that anyway. We're a recommending body
You're-
exclusively.
Yes, Michael, right, exactly.
You're conducting a hearing to determine if this ordinance is defective in that fashion. So you're not determining that it is definitely defective, et cetera. You have a hearing. In fact, in this Bedminster case that I'm talking about here, there were 50. Let me say that again, 50 hearings in that case before a decision was made. That's how complicated and convoluted this law can sometimes be.
All right, procedurally, time-wise, what are we under?
We have to have an official,
Okay.
when I say we, the township supervisors,
Yes,
have to have its public hearing by August 11, which is the date that is presently advertised for.
right.
That's the 60-day deadline,
That's the
unless
60.
the applicant would agree to extend the time for a hearing. But right now, the matter has been advertised for August 11, which meets the deadline, and unless something changes, I don't see why that deadline can't be.
And
met.
my recollection is that's gonna be beyond. Yes, because otherwise our meeting would be on the second Thursday, which would be
Right.
2 days after that. All right, so
Right.
we have to do something.
Right, that's why you put it tonight.
Yeah, go ahead, Robert.
Going to Doug's question, I think, clarify this right. What you're saying is, if this was.
Can't hear.
Can you hear me?
Keep going, I want to see who else is here.
Asking Ron a question,
Keep
just to
going.
clarify
That's it.
Doug's question and get an answer, which is.
We're still coming in.
Oh, if this is cured by allowing it, it's only for this one facility, it's not for the entire R1 district. Is that what you're saying or not?
Right now, correct. I believe now, again, I heard Jim say he disagrees with that, but he was stopped
Okay.
because we were talking, but he can speak, when he has that opportunity. But I believe it's site-specific relief now. That's how I'll classify it. That applies to this site because anyone else that would apply, this defect, if you want to call it a defect, has been cured by the ED amendment.
All right.
What was Jim's question?
All right, now we can get, we'll let Jim go, and then if Mr. Wolf wants to say anything in response. All right, Jim, what were you gonna get to?
The Piper case, the holding of the Piper case is basically that I agree with Ron in part and disagree in part. I do agree that you have to have a hearing on the application for a curative amendment, but the Board of Supervisors is free to agree or to come up with their own solution to the problem of the use not being permitted, at least prior to the economic development zone being adopted. And in the Piper case, as Ron said, they had 50 hearings, and after the 50 hearings, they determined that the alternative proposed by the supervisors, not the applicant, was appropriate. And the Supreme Court held that and under the statutory language, under Section 609 of the MPC, the board is free to fashion a remedy in the zoning ordinance that's different than what's proposed by the applicant. So you're not obligated to adopt the applicant's.
Jim, we lost your sound.
Can you hear me now?
I can hear him.
We can still hear him.
All of a sudden, it just said, hang on one second, Jim. It said, switch off the default speaker setting. No, we didn't.
Keep talking, Jim. We'll tell you if we.
The language under the municipal planning code specifically states that the board does not have to adopt a specific solution suggested by the applicant, and they can fashion their own solution. That's right in the MPC in section 609.1, and that's backed up by the Piper case. The Piper case actually upheld what the board did, and it said it followed 609.1. And they had, like Ron said, they had 50 hearings. After that, they determined that it was not, the solution proposed by the applicant was not the one that they wanted to adopt. So I think the Planning Commission is free to make a recommendation to say that the proposed solution of the applicant is rejected, and then it's up to the supervisors to have the hearings and to make the determination. We're not locked in to what the supervisors or to what the applicant is proposing. The other point that I made earlier was that the proposed ordinance that's been proffered by the landowner is not site specific. It says any property in an R1 that's 25 acres or more is eligible to have a drug and alcohol treatment center there. And there's more than just this property in the township that qualifies under that standard. So what my belief is that the board should determine whether or not this is a suitable solution, and then the legal issue should be determined by the supervisors. But I believe that the legal issue clearly is that the supervisors could, if they desired, not reject the solution proposed by the applicant and come up with their own solution. And that most likely would be what the board just adopted in the economic development zone, allowing this as a permitted use in an economic development zone, which is entirely appropriate in my opinion.
And Jim, you think, before we get Mr. Wolf involved, Jim, you think that under Piper, that would suffice for example, for the supervisor to say, okay, here's our cure. It's the ED zone.
Yeah, but the Piper decision specifically states that. It specifically stated that what the supervisors did was affirmed because it followed 609.1. It had multiple hearings. It carefully considered what the applicant was proposing, and it rejected that. And that's based on the statutory language in the MPC. The township is not beholden to the applicant to adopt their specific proposal. It can consider. If you look at the ordinance, it says that the board shall consider a wide variety of impacts that the use would have on the zone where it's proposed by the applicant. And then after they do that, consider, what is the most appropriate zone for this use to be located in. The ultimate cure is for the board to determine what is the most appropriate zone, which I would submit the board has already done by merit of the ordinance that they've already adopted. But I do agree with Ron that you cannot just say it's moot at this point. You have to go ahead and have the hearing, and the planning commission would have to make a recommendation, what they think is most appropriate.
All right, now let's let Mr. Wolf have his turn here. So everybody can hear you, Andy. Why don't you come up here? At least stand here. Actually, no, why don't you sit here in where Ron is? Because it'll make it easier for this to pick up.
Go.
Thank you, Scott.
Yep.
So reasonable minds can certainly differ on what a case says. We rarely, I think, have such a clear statement of what this section of the MPC means, section 609.1. And we rarely get it from the Supreme Court, which is the final authority on it. But this Piper case, I think you have to understand that on the facts of the case, which I think was what Mr. Ferrari was talking about, that applicant lost because they tried to piggyback on an earlier applicant who had filed a curative amendment. And then it was passed, and then this other applicant came in after the fact, which is why Mr. Karasek said you really have to look at the dicta of this case. What it stands for is what 609.1, which is the applicant's curative amendment procedure, versus 609.2 of the MPC, which is the township's procedure. We're dealing with 609.1. That's what this case stands for. And really the primary point that the Supreme Court makes here is, sure, the township can come in and pass its own ordinance that comes in after the fact, or the township can reject our curative amendment. That's within their prerogative. But the impact of that would entitle the applicant here to site-specific relief. In other words, the township can't defeat an invalid ordinance that's exclusionary, which we've already established here, by proposing an amendment that still does not grant relief to the party that's saying it's invalid. That's really what the Piper case stands for. So and I think those are the facts that we have here, and that's what's in dicta in this case. And I think it's quite clearly stated by our Supreme Court that the township, if it were to reject my client's curative amendment request, would place itself in the position of effectively granting them site-specific relief. That's clearly stated in this case. I think the court would uphold that. The other aspect of this is that you had this ordinance pending. Excuse me, it wasn't pending. You had been kicking this around for 3 years, I believe. This economic development ordinance. The timing is such, and the cases are very clear on this. The timing was such that, as I think Mr. Karasek indicated, our curative amendment was to the township. The request was made. Subsequent to that, the township advertised its intention to pass the economic development ordinance. And again, the cases are very clear on this. Unless the township had that ordinance pending, and pending is defined as it's been advertised for adoption before our curative amendment came in, it does not cure the situation. So the fact that you've passed the economic development ordinance, which I actually think is a good ordinance as it relates to the development of the township generally, does not moot this, certainly. And furthermore, if the township were to deny my client's request under this pending curative amendment, I think it is clearly entitled to site-specific relief. So,
Okay, would you just speak to this one question that I have then, Andrew?
Sure.
Corollary, what we discussed earlier with Jim, and that is, it sounds to me like the only obligation the supervisors in this case have is to hold a hearing on the curative amendment, specifically to take up your particular and specific curative amendment, and then either to reject it and replace it with something else that also has the effect of curing the defect in the ordinances, or not, in which case then then as a result of that hearing, there would be appeals, probably from either side, depending on how they decided. Is that correct? Or want to be clear enough?
sure. I think you're correct that the township must hold a hearing on this since it has been advertised. It's come in. They can't just simply say it's gone. I think the point that you ask is, what is the township's obligation beyond that?
Right.
And I would answer that they make a determination. That's a legislative decision for the township to make, whether they decide to adopt the curative amendment as proposed, or adopt or reject it, or adopt something different. The question comes in if they either reject it or adopt something different that does not allow the applicant, in this case, Water Gap Capital Partners, to have that use on that property. That's when the site-specific relief comes in. So the township well, I'm just trying to answer the question.
I understand.
Based upon section 609.1 and what the Supreme Court has indicated. In essence, what they're saying is a township can't defeat an applicant's curative amendment by curing it some other way that does not give any relief to that applicant.
Let me say this.
That's my interpretation.
Let me say this, Mr. Chair, and I was going to follow up in that regard. This Bedminster case, and I'm looking at now, this is printed out. I'm not sure how it's printed out.
That's all right.
It's on page 9. The Supreme Court is citing prior cases known as Casey and Fernley and various other cases in this issue. And they say, we further explain that under Casey and Fernley, the municipality could not be permitted to amend or modify its ordinance in such a way that the defect was cured, but the landowner who had raised the challenge obtained no relief.
Okay.
Now in Bedminster, the applicant got some relief. They didn't get everything they wanted, but they got some. And that's why the Supreme Court said, okay, you're going to lose because you got some relief. Here, there would be no relief to the applicant. So that I think that this would apply if in fact we say, no, when I say we, the township would say, no, we're not going to agree that this is a defect because obviously they don't have property in the B2 zone. If they had property in the B2 zone, maybe it might be a different deal. And to answer Doug's question, I'm looking right at the section. The governing body of municipality, if it's determined that the challenge has merit, now that's important. They have to first make that determination. They can either accept the curative amendment as filed, they can accept it with or without revision, or they can adopt an altered amendment, which they would believe would cure the challenge or the defect. So that's the options the township supervisors have after that year.
And if I'm sort of finding a center to all these different opinions, I'm getting that the township could say, maybe won't, but could say, we're going to cure it with the ED zone. Or they can say, we're going to cure it and we'll allow it in the R1 zone, but we're going to make sure it's site specific. Right.
We're going to make sure it's a 25-acre minimum, which if it's site specific, that sort of may or may be moot, et cetera. And add some other reasonable conditions in the ordinance. Now, not the conditional use. Remember, the second step here is then there's a conditional use hearing where conditions can be imposed. So they could do that too. So they have a number of options. They can say, no, we think we've cured it. And I'm not going to get into whether or not that's right or wrong at that point, because that's a policy decision to be made by the supervisors.
Yes.
Or they can just.
Ron, I'm going to go one step back. I don't think we should be here to curative amendment at all. It was in the original B1 zone, this sort of hospital use. I don't think there's anything to be cured.
Well, let me talk about that.
Yes.
Yes.
Agreed.
But the zoning officer did not make that
No,
call.
I understand that. I'm just telling you, there's a third thing here.
There's a third thing where you can say this
Much for Andy's blood pressure, but there's a third
that
thing.
this was a rehabilitation center, whatever, et cetera, et cetera. And the supervisors decided that didn't apply to drug and alcohol issues.
Okay.
It applied to physical disabilities. And that's why we sort of got that ball rolling.
All right.
Can I just address that?
Yeah, you can go.
I think Judge Zulik disagreed with you in his decision, which was issued on June 10th, and no one has appealed that decision. So I would submit that the decision stands for two things. The first was that he disagreed with the procedure that was used to under Section 302, but more importantly, it stands for the proposition, in my opinion, that the ordinance was exclusionary as to that use. And again, that decision has not been appealed. So I think the first step of that inquiry under a curative amendment has already been established. And I don't think we can back that up.
Okay.
And just.
If
for a
I-
moment,
Am I allowed to chime in at this point or not?
Yeah, you can chime in, Jim. Go ahead.
Okay, I agree with you, Scott, what you said. I think this use at the very beginning, which should have been done, this should have been determined to be a specialty hospital, which is a B2 use, and it should have been considered in that zone. And I disagree that Judge Zulik's decision
I understand.
negates that. And I think that that's still a basis that the township could hang their hat on now. And
So we have three different things here that are going to end up in front of a judge, irrespective of whatever we do tonight. Am I right?
I believe you're correct.
Okay.
Can I ask a question?
Go ahead, Dave.
This is David. I want to kind of dumb this down for me. The way I'm hearing this, all this legal talk, is that there was a discrepancy in our ordinance that did not allow specifically a drug rehab facility. So the applicant says they want to put one on this golf course. So we have to cure that. But regardless of what we do, we have to allow them to put it there because we didn't have it in our ordinance. Because we have to grant them some kind of relief. Is that what I'm hearing?
Sort of. Ultimately, that would have to be court blessed.
Yeah, this is Ron. Dave, I don't know if we would have to grant that. And also, I disagree a bit with Attorney Wolf with respect to what Judge Zulik said. He basically said the supervisors did not have jurisdiction to make the change through that section 302 of the zoning ordinance. They had to file a municipal curative amendment process or general amendment process. That's not the same as saying the ordinance was defective or that the ordinance did not cover that. So I disagree. The order is very clear that the case was lost as to the township because he felt the township, in fact, I have the order right in front of me.
Okay.
He felt that the township, just give me a moment here, the supervisors did not have the jurisdiction to make the determination without amending the ordinance. So I think it's a different look, but again, there's different lawyers and different ideas and different things, and that's.
So explain to me what the options are for us moving forward. I mean, the supervisors are obviously looking for a recommendation from us on how to cure this lack of a drug rehab facility in our ordinances.
Your options, Dave, when I say the planning commission can say, as chair just aptly noted, there is nothing to cure. We believe that this was taken care of in the old ordinance under the whatever zone it was, B2 or whatever, or that, yes, we believe it does have to be taken care of, but this is what we think the ordinance should address or do. Or we agree with the ordinance as presented by the landowner, and if Jim is correct that it seems to apply throughout the R1 zone, obviously I would recommend that that's not the recommendation because I don't think that's where we are at this point. Based upon the Bedminster case, I think it applies only to the water gap property.
Okay. All right.
Can I just insert one thing?
All right.
I'm going to read a quote out of the Monroe County Planning Commission, item 4, in their recommendation. The township should carefully consider if the land use in question is appropriate and consistent with the intent of the R1 low density residential district. Due to the nature of the land use, it may be more appropriate within a non-residential zoning district. It should be noted that while residential uses are not permitted in C1, M1, B1, or B2 districts, Section 304 of the zoning ordinance specifically permits medical and healthcare uses where patients would reside on the premises. This should be discussed. That's
That's what we were discussing.
pretty much what Scott just said. So
And you can say, we're not even going to get to an economic development zoning district.
Mhm.
We believe that the old zoning ordinance had this issue covered and there is no reason to cure it.
Okay,
Which that could be the recommendation that the commission may want to make.
right, which I would point out, we discussed, but way back when we were first looking at this, And you said, because the supervisor already written their letter of decision, you said that train's left the station. So we're bringing the train back into the station.
On that issue, but yes, this now, I can tell you, and I won't speak for Attorney Wolf,
Okay.
but I will in the sense that had he known, or any of us known, that the court was going to say that the supervisors had no jurisdiction to act under the specific provisions of the zoning ordinance that is supposed to cure these problems, he would have filed a landowner curative amendment out of the box.
Back then.
Oh, yes,
Back then.
sure.
Okay. Well, I think this is going no matter what. So
What's going on?
this is going to court no matter what. So at this point, I mean, I'm ready to make I'm ready to,
I welcome it.
I'm actually going to I'm going to make a motion that the curative amendment be rejected in that it was already addressed in the prior zoning ordinance. With, of course, all due respect for all of the learned opinions that we've had around here. This has actually been quite a discussion. But I'm going to make that recommendation and that motion that it be rejected as undertaken in the prior zoning code.
Yeah.
Even before we did the amendments.
Is there a second? See if there's a second, and then you can.
Is there a second?
Second, David.
David. All right, any other discussion? All right, board, we got to vote. All in favor?
Aye.
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 3, Bob?
Aye.
4.
So we got 5 then altogether.
4, I think Michael had to leave because he had to go back to the,
Michael had to leave.
yes, it's 4. It's David and Robert online and Doug and me.
Mr. Chairman, just to clarify, this is.
One, I don't mean to interrupt.
Yeah,
you.
that's
I
good.
just want to make sure this is okay. Dave, were you here when there was the vote on the minutes, or were you not here yet?
Who's that?
Dave, this is
Yeah, I've
Dave.
been here from the beginning.
Okay, yes.
All right.
So you did vote for the minutes too. Okay. All right, thanks.
All right, I'm sorry, Doug, go ahead.
Go ahead.
I forgot.
Okay.
Mr. Chair, Scott, I did have just a question for clarification.
All right.
I understood your motion.
Yes.
You're saying the curative amendment should be rejected.
Yes.
Due to the passage of the economic.
No.
No.
It should never, it should, there be no curative amendment to begin with. It was in the B1 zone.
That, what Scott is saying, that there was ample provision
Yes.
and ample verbiage, what should I say?
That's fine.
There's provision made in the prior code.
Ordinances For just such a,
And that's your recommendation. The zoning officer may disagree with you. The supervisors may disagree
no
with you.
doubt.
And Judge Zulik and I have disagreed with each other many times over the years, so it's how it is.
That's the recommendation that's being made, and that's what will go to the supervisors.
Okay.
Although 2 of them are here, so
Well,
they've heard it for themselves
Understand.
when they have the hearing.
Mhm.
So
And then, so the hearing will be scheduled for August 11th?
it is already scheduled.
Our
7
recommend,
o'clock here. It's also a Zoom meeting.
okay.
And I've noted that if people want to be personally present for that, they can be, but we probably can't have more than 10 people
But a limited number of
in the
chairs.
room,
Mhm.
in addition to the supervisors, the engineer,
Yes.
the solicitor, et cetera.
All right.
So I basically put in the notice, it's on a first come, first served basis.
All right. Well, then that's actually all the stuff that we had on the agenda this evening.
Next meeting for this body.
Well, I'm not sure we're going to need anything the next meeting. It would be August 13th, and we'll see if there's anything that's required to be on that.
I think you may have the magic cauldron to.
Well, I know we tabled it. Did we have,
We did,
did we
but-
table it only one?
We tabled it while we were waiting for John's review, and then, in fact, they asked it to be tabled. I'm sorry.
Yeah, they did. They asked.
Waiting for John's review, and they wanted to reply. So now we've got like 6 reply letters from them.
Oh, okay. So we do have to go. We
So
will have to meet on the
I was thinking-
13th.
now, I haven't seen one from the Monroe County Planning. Did one come from Monroe County Planning? I don't recall. I don't know either, but in any event, and then there's another one that came in just a week or 2 ago. It's the Fredericks and Wyckoff. So it's a lot consolidation plan.
Okay, that's a
So-
joinder.
So the 11th is a Tuesday and we're
That's a Thursday for our meeting. Tuesdays are the supervisors. We'll meet at 7 o'clock, August 13th,
okay.
in this hybrid format. I make a motion that we adjourn the meeting.
Second,
second by Doug. All in favor?
Aye.
All across the board. Thank you, everybody.
Hey, everybody.
Thank you, everybody.
you.
Thanks.
Take care.
Thank
Have a
you.
good night.
You too.
Thank you.
Jake.
Yes, sir.